Question. Upon the lapse of the 15-day period to appeal, is it correct that an order can become final and executory? Hello, I'm Attorney John Edmond Cruz, and you're listening to this series of Rights of the Accused. Together, we spend a few minutes of the present to gather lessons from the past as an investment for our future. So, to answer this question, I would like to add certain facts or principles. In a certain case, litigation, a party, either party, can receive a favorable or unfavorable decision. Generally, you would like to appeal the unfavorable decision or a portion of the decision that is unfavorable to you. So, normally, to appeal or to raise it to a higher court or to represent it to the same court, you would argue that the decision is wrong. That is why it is unfavorable to you. That is why you seem it is unjust or unfair to you or violative to your rights. Basically, that would be the gist or the main point of your appeal, that perhaps the judge misappreciated the facts or misapplied the law or arguments along those lines. So if you think an order, decision, judgment is wrong, you have a certain period to appeal. Normally, in most common cases, that would be a 15-day period to appeal or to file a motion for reconsideration or a motion for new trial, depending on the phase of the case and the facts surrounding the case. At certain times, this appeal will be strictly, this period to appeal or period to file a move for reconsideration or new trial is strictly applied. That is why there is a good amount of authority, Supreme Court cases citing the rule that upon the lapse of the 15-day period to appeal, an order can become final and executory. Stated otherwise, as a general rule, it becomes final and executory upon the lapse of the 15-day period. This is the lesson that you will find in this 2005 case that I will be sharing to you. In these videos, I will share the opinions of the court to you and try to explain in layman's terms how these portions of the decision will matter to you. I will share to you this paragraph. I will paraphrase a bit so that it will be easier to understand. The Supreme Court said, it is correct that an order or resolution of the Sandigan Bayan, in the Philippine jurisdiction, this is what you call the graft court, ordering the dismissal of criminal cases becomes final and executory upon the lapse of 15 days from notice thereof to the parties, and as such is beyond the jurisdiction of the graft court to review, modify, or set aside, if no appeal therefrom is filed by the aggrieved party. So normally, if the decision or order or judgment is favorable to you, you would not appeal, Although at times, that is why I would say generally, because like for a certain exception, a favorable judgment of, let's say, you were awarded 1 million worth of damages, but what you really want, is 5 million. So that 1 million, although you won the case, it could be favorable, but it is also partly unfavorable because it does not satisfy the full amount that you really think is fair. So this 15-day period to appeal or the prescribed periods to appeal under the rules of court or under the rules in the Sandigan Bayan is not absolute. There are exceptions to this rule. So these exceptions I will discuss in the next videos, as this case of before the Sandigan Bayan prior to arriving at the Supreme Court is an example. So remember, if you receive an order, judgment, decision, whatever you call it, anything, any paper from the court that you think is unfavorable to you, or in your opinion is wrong, or there was a misappreciation of facts or misapplication of the law based on the facts, you have a certain period depending on what court it is pending, no? Depending on the facts of the case, depending on the situation pending at the time, no? Depending on the current situation and the rules that will apply, you have a certain period to request, to pray for the rectification of the order or decision because you think there was a misappreciation of the facts or evidence, or perhaps a misapplication of the law based on a set of established facts supported by evidence. So there is a strict rule with respect to these prescribed periods to request for rectification of unfavorable order or decision by the aggrieved party. Most of the time, that is strictly applied, but that is not absolute. There are certain exceptions. Listen to our next video so that we can discuss the example, no? A nice example on an exception to the strict application of this rule. So that is our video for today. If you like our video, please click the like button, follow our page, share this to your friends, and subscribe. Thank you.